face will be in court or will be in front of private arbitrators. Most litigation lawyers prefer court, and most litigation lawyers will make more money in court. If you go to court, the court is pretty inexpensive. It's almost free. The judge may be very good or may be very bad. You will normally have a jury. How many of you have gotten out of jury duty? Okay, so the people on the jury are the ones who didn't get out of jury duty. The juries can be very difficult or they can be very good. You just never know. But it's very expensive to choose a jury, and then it's very expensive to conduct a trial during a jury because the jury can't hear this and they can only hear that, and they go into the room, they go out of the room. So you can put in your contracts, we waive trial by jury. So if I'm representing somebody who's selling a product, or I'm representing somebody who's employing somebody, I at least want to waive trial by jury. Every state has special language requirements on how you waive trial by jury. The next question is, do you want an arbitration clause? So instead of going to a jury trial in the public record, the arbitration organization chosen, which could be a state organization or quite commonly the American Arbitration Association, AAA, you can go there on your way to AA, you can remember it that way. They will give you a list of arbitrators. So if I'm going to get into litigation, I have to file an arbitration complaint. The filing fee is commonly $10,000 or more, so people are going to be reluctant to sue you with American Arbitration Association. The loser commonly pays, and the American Arbitration Association normally will appoint 3 arbitrators, which gets really expensive. So personal injury lawyers don't like arbitration. They have no emotional jury, and they don't have a bad judge they can manipulate. Remember, judges always run for re-election. They don't want anyone to hate them. Anyone who gives them $500 for their re-election is going to get some degree of respect. Arbitrators don't really care about that. And litigation lawyers can be intimidated by arbitrators because typically the arbitrator, when I write a contract, I ask that it will be an arbitrator who specializes in that area of law, has an AV rating in Martindale.com, and at least 20 years experience. Now, what happens is if it's one arbitrator, for example, AAA will send you a list of eight names. And I can blackball 4, and the other people can blackball 4, something like that. So we end up with somebody who's not so bad. They may blackball the really good one because they want to try to fool a mediocre one. But you end up with, I think a better result. But what I like most about arbitration clauses is that lawsuits, in my experience, appear to settle much more quickly because the litigators are much less enthusiastic about jumping in. So, you know, that's it. So are you asking your customers to sign arbitration clauses? Does the provision say we'll go to litigation if it's a dispute about paying what's owed, but we'll go to arbitration if it's a dispute about anything else? That may be enforceable in your state. Do your agreements with customers also say that the customer will indemnify you and hold you harmless for anything bad that happens, as long as you were not reckless? And those contracts will commonly hold up. When was the last time you even read your customer agreements? Your customers don't read them, so you might want to put in there anything you like, right? Because I'm your lawyer, I'm not your customer's lawyer. I'm sure somewhere there's something. Marcia was on the phone with customer service when they told her to go up the ladder. I'm sure there's something in that agreement that we have with them which says that if she fell off a ladder, it would not be their responsibility. Now, page 35. Just put this on the wall when you start your litigation. When you march into the lawyer's office and says, this is a matter of principle. It's not fair. You know what? Just spend that amount of money putting an orphan through college. Because all you're going to do, if it's a matter of principle, is waste your money. And by the time you're done, you'll have crossed where the matter of principle steadily declines in value and the money you've spent steadily increases in value.